One wrong sentence during a traffic stop, and your lawful gun ownership can flip into a felony. I'm talking about exact phrases officers are trained to repeat in court, even when you think you're being helpful, even when you think you're being truthful. Today, I'm breaking down the 5 most dangerous things gun owners say to police that can wreck their legal defense. By the end of this clip, you'll know exactly what to say and what to never say when an officer asks about your firearm. This isn't hypothetical. Last month in Texas, a concealed carry driver said 3 words during a routine stop. Those 3 words cost him his carry license, 15 grand in lawyer bills, and 24 months of court fights. He thought he was doing the right thing. He was dead wrong. Number 1, I didn't realize. When an officer figures out you're armed in a forbidden zone, maybe a post office lobby, a school lot, or a city building, your first instinct is to explain. And the most common line is, I didn't realize that was illegal. Here's the trap. Under the rule of ignorance of the law, saying I didn't realize is not a defense. In fact, it's a confession. You just told the officer you did the act. You carried inside a restricted place. Now the only fight left is intent, and you just erased any argument your counsel could build around that. In 2023, a Louisiana carrier said exactly this after being spotted armed in a courthouse garage. The district attorney used his own sentence against him. Result? Class B misdemeanor, 2 grand fine, forced surrender of his concealed license for 3 years. His attorney later admitted the case might have been tossed if he had simply stayed quiet. Here's what you do instead. If the trooper says you're in violation, you volunteer nothing about what you realized or didn't realize. Your one line is, I'd like to consult counsel before answering questions. That's it. Your lawyer can deal with knowledge and intent later after they've studied the actual statute and built an actual defense. But here's what most owners skip. And the next line is even riskier because it sounds cooperative. Number 2, it's only in my pickup. You're stopped for a busted taillight. The deputy asks if there are any weapons in the vehicle. You want to sound cooperative. So you answer, yeah, it's only in my pickup. Or, it's only in the glove box. That tiny word only can legally equal an admission of possession and control. In front of a jury, the state will argue you knowingly placed the pistol exactly where you described it. And if that location breaks a local rule, maybe you're parked beside a campus. Maybe you crossed into a state with tougher storage laws. Maybe your license doesn't cover vehicle carry. You just handed them every element they need. Florida, 2022. A driver told a trooper his handgun was only under the seat. The trooper found it loaded and not in a locked container. Under Florida statute 790.025, that can be unlawful without a carry license in certain contexts. The driver did have a license, but it had lapsed 2 weeks earlier. His own description of location and accessibility was used to prove he had instant access to the weapon. That bumped the charge to carrying a concealed firearm without a license. A 3rd-degree felony with 5 possible years. Your proper reply. If state law forces you to notify, you say, I'm informing you I'm a licensed carrier. Period. No address, no details, no extra storyline. They'll ask where it is. You say, I'd rather discuss that once counsel is present. That can feel uncooperative. I get it. But cooperation on the roadside does not mean volunteering information that can be used against you later. Which brings us to sentence number 3. This one gets more people jammed up than they ever expect. Number 3, I possess a license. Wait, aren't you supposed to say that? Not exactly. The problem isn't announcing a license. The problem is what usually comes next. Picture it. You say, I possess a license. The deputy demands to see it. You reach for your wallet, except your permit expired last month and you forgot to renew. Or you moved and didn't notice your old license isn't honored here. Or you're in a jurisdiction that rejects your exact license class. Now you've given a false statement to an officer. That's a separate crime in 43 states. In Virginia, it's a Class 1 misdemeanor up to a year in jail and a $2,500 fine, completely separate from any firearm charge. Tennessee, 2024. A permit holder informed a deputy during a traffic stop, I possess a license. The deputy ran the database. The license was suspended over an unpaid citation from 6 months prior. The driver had no idea. The district attorney charged him with carrying without a license, plus giving a false statement to law enforcement. Final bill, 8 grand in lawyer fees, 40 hours of community labor, and a lifelong entry on every background screen. Here's the safer wording. I'm a licensed carrier, and I'd prefer to confirm my current status through counsel before continuing. If the card is valid, your counsel confirms it on the spot, and you're clean. If there's a glitch, an admin error, a late renewal, a reciprocity snag, your attorney handles it before you've said a single thing the state can quote. Now we hit number 4. This one feels like you're protecting yourself, like you're being responsible. But in court, it can hand the prosecutor proof of intent. Number 4, what's for safety? An officer asks why you're armed. You want to sound sensible, responsible, law-abiding, so you say, it's for safety, or I carry for self-defense, or you never know what might happen. You just established motive and intent. If your carry situation is later ruled illegal wrong, zone, wrong license, wrong state, the district attorney now owns your words. Words that say you intended the weapon to be accessible for use. That can upgrade the offense in many places. California has some of the tightest firearm laws in the nation. In 2023, a CCW holder was caught armed inside a posted no-gun zone. When asked why he was armed, he replied, for safety. There's been crime around here. The prosecutor used that line to argue he deliberately ignored the signage because he valued personal safety above the law. That turned a possible misdemeanor into a claim of willfully violating firearm restrictions. He burned 12 grand and 18 months fighting it. Here's how the court hears it. If you say you're carrying for safety and later they find you in violation, you've confessed 2 things. 1, you knew the gun was on you. 2, you intended it to be ready if needed. Knowledge and intent. That's exactly what the district attorney needs to chase harder charges. Your reply when asked why you're armed is simple. I wish to speak with counsel. That's the one answer that protects you. Don't rationalize, don't explain, don't feed them material. And now we hit number 5. This is the line that obliterates more defenses than anything else, and I bet you've considered saying it. Number 5. I wasn't planning to fire it. This is a panic reflex. The deputy finds your pistol and you want to calm everything down fast, so you blurt, I wasn't planning to fire it, or I forgot it was even there, or I never touched it. Congratulations. You just confessed to unlawful possession while also torching your Fourth Amendment argument. When you say I wasn't planning to fire it, you confirm you knew the firearm was present. That kills any claim the gun was planted, that you didn't know it was in the vehicle, or that someone else stashed it there. You just locked yourself into possession. When you say I forgot it was there, you've admitted negligence. In states with mandatory storage laws or cases involving prohibited persons, negligence can be its own criminal count. Now you've handed the district attorney a second violation. When you say I never touched it, you invite forensic scrutiny. If your prints are on that pistol, and they will be if you own it, you've now made a false statement. That's another charge. Georgia, 2023. A driver got pulled over with a pistol visible on the rear seat. When the trooper walked up, the owner quickly said, I'm not going to fire it. I forgot it was back there after the range. The trooper cited him for improper storage and transport. The district attorney used his own words to prove he knew the gun was in the car and failed to secure it correctly. Under Georgia code, it should have been a $100 ticket. His statement upgraded it to a misdemeanor, $1,000 penalty, and a mandatory safety class. So what's the correct reaction if an officer locates your firearm? Silence. Literally say nothing. If the deputy starts questioning you about it, your line is, I'm exercising my right to stay silent, and I want counsel. That can sound harsh, I know. But here's what you need to understand. Anything you volunteer in that moment is used for 2 things: to protect the officer's safety and to build the prosecution's file. Nothing you say will improve the stop. It can only make it worse. Recap. The 5 sentences that can wreck your defense. 1. I didn't realize. Confesses guilt and wipes out any ignorance angle. 2. It's only in my pickup. Proves possession and control at a precise location. 3. I possess a license. Opens you up to false statement charges if anything is off. 4. It's for safety. establishes intent prosecutors will use against you. 5. I wasn't planning to fire it, confirms knowledge and demolishes your Fourth Amendment defense. Any one of those lines can cost you thousands in fees, your carry license, or your freedom. When police ask about your gun, your one safe sentence is, I'm exercising my right to stay silent and I want counsel. Hit that like and subscribe button and help us reach our 10,000 subscriber milestone. Every single subscriber matters. Your support is what makes this journey possible.